There's a federal judge out there, Will. There's at least one who's saying, I don't think we should be getting involved so much in this judicial activism, and so much so I'm going to put pen to paper and put it in one of my rulings, because this is the point. We have a federal judge on Monday who denied a request by a Maine Family Planning provider. This was someone who said, hey, we provide abortions. We're not Planned Parenthood. We shouldn't be stripped of our federal fundings because we're not Planned Parenthood. And here they are. And, of course, that judge stuck his neck out quite a bit.
This is in the U.S. District Court for the District of Maine. This judge put an order down on a preliminary injunction that was requested by the Maine Family Planning Association. They wanted a preliminary injunction to stop the defunding of their work, their abortion business. And what this judge goes to show in denying that preliminary injunction, so effectively saying they are still defunded by the big, beautiful bill, he didn't just stop at saying, here's my rational basis for why I'm denying this preliminary injunction. He writes at length about why it is not the role of the judiciary to do this, including lines like this. Undoubtedly, most of the public that is outraged by Congress's defunding of, quote, prohibited entities will feel as though they do because they find the provision unwise, unfair, and illogical. In fact, much of plaintiffs' arguments turns on a public policy critique of the prohibited entities portion of the big, beautiful bill. However unwise the prohibition of Medicaid funding to providers best positioned to deliver Medicaid services to underserved rural populations, the judicial branch, despite much generated confusion on this basic point, does not serve as an omnibus super legislature to sit in final judgment as to which policy outcomes it prefers. That judgment rests with the people. Basically throwing shade through this order at the judge in Maine, in Massachusetts, which jumped through all these hoops to grant preliminary injunctions to not just Planned Parenthood of Massachusetts or the National Planned Parenthood Federation for America, but to all of Planned Parenthood members. This judge is saying, we're not a super legislature here. This isn't our job.
You finally kind of have a federal judge who says some nice things. Maybe says, hey, my nice things, I mean, say, hey, other judges, quit it.
And this also points out why it's so important that the ACLJ engages these cases. This judge that denied this preliminary injunction request did so directly, but with some language that is very similar to the brief that we filed. Listen to this part. This is from our brief that we filed with the court in support of the administration and the government and the big, beautiful bill's provision. And we wrote, ordering Congress to spend money it has declined to appropriate would violate the separation of powers. The appropriations clause reserves power of the purse exclusively to Congress. Courts cannot compel Congress to spend money any more than Congress can compel courts to decide cases. The relief plaintiff seeks, an injunction forcing Congress to fund its operations, would transform federal judges into super legislators empowered to redirect public resources according to judicial rather than legislative priorities. That entire point about the separation of powers. The judge writes, the Constitution gives the Congress of the United States the power of the purse. The very first enumerated legislative powers of Congress are the powers to raise and spend money. And this means that Congress, not the executive branch or the judicial branch, has the authority to determine how to spend or not spend the nation's dollars for the achievement of, among other things, the, quote, general welfare of the United States. So why do we file in these cases, even when the government has their own attorneys that are fighting this, when a plaintiff is suing the government? Obviously, we are not representing the government. The Department of Justice and the Council of HHS are.
There.
But when our attorneys, I've read you the words, those are powerful words that are echoed in this judge's opinion. Our attorneys are very good at this, and they know what to write and how to write and explain the law in such a clear-cut way that you start to see these things echoed in the opinions of the judges. We talked about last week where we filed in that case, in that appeal of that enormous judgment of over $500 million against President Trump. One of the concurrences from one of those justices directly quoted the ACLJ. That is because we hire the best of the best. They are savvy, smart attorneys that know how to write these briefs so that it gets the attention of these judges. When they read it, they know the power of it and the weight of it, and they know it's the law. And many times that's why you see it reflected in their opinions.
Yeah, a lot of times reflected, as Will said, either word for word or like someone, copying your homework, just like slightly altering it. You're like, oh, I wonder where they got that idea from. Obviously, it's from our ACLJ team. They have the tools and the talent to get stuff done.
But I want you to read this other part for this judge out of Maine and really directly taking shots at the Massachusetts judge, if you read it. And it says, the plaintiff's predicament is complicated by a longstanding cultural battle over the availability of abortion spanning nearly 50 years. It was considered a constitutional right. However, 3 years ago, the Supreme Court held that abortion is not a right protected by any constitutional provision, and as such, quote, the permissibility of abortion and the limitations upon it are to be resolved like most important questions in our democracy by citizens trying to persuade one another and then voting. That's from the Dobbs decision. Then this judge goes on to say, that is precisely the type of democratic exercise that produced the big, beautiful bill. It would be a special kind of judicial hubris to declare that the public interest has been undermined by the public, effectively saying that our democratic process, the very thing that we are told all the time by the left is in crisis, our democracy, that democratic process is what led to Congress getting elected, President Trump getting elected, and this bill getting passed. It is a, quote, special kind of judicial hubris to try and claim that there is a public interest that is being harmed by the public, because that's how our democracy works, our democratic republic. So he sees this very clearly. The democratic process worked. The remedy, if you don't like that, is to change the minds of your fellow people and how they vote, not to rush to the court and try to get policy decisions changed by the courts. This judge has it exactly right. I love the very much some of the flavor to this that you can see that was probably drawn from even the brief our attorneys wrote. It lines up very directly, and it makes me proud to be a part of the ACLJ and the legal team we have fighting here, but also that these judges are brave enough to call out other judges for a special kind of judicial hubris, because that's what we've been seeing for far too long.